Buhari tells political factions in Chad to respect democratic transition process in that country.
Terrorists kill divisional police officer and inspector in Zamfara.
NNPC Limited assures of nationwide petrol sufficiency in March.
And on Good Morning Nigeria today, we shall discuss election litigation.
It was Winston Churchill who said, "To Georgia is better than to war." That opens our conversation today on election litigation. The 1999 Constitution, as amended, provides the courts of law with the powers to preside over disputes between citizens, institutions, and even political parties.
Therefore, in the aftermath of an election, aggrieved political parties and candidates are expected to adhere to the rule of law by seeking redress in a competent court of law rather than resort to violence or self-help. So, under the Nigerian law, that's to say the Constitution as well as the Electoral Act 2022, aggrieved persons, again parties and candidates, have the option of resolving their grievances through the law courts.
Election litigation is bound to occur in an electoral process, and this is not peculiar to Nigeria, as it is indeed a global phenomenon. Now, the only difference perhaps is the behavior of judiciary and the parties to the dispute. Back home, the 2023 presidential and National Assembly elections have been quite intriguing, and few critics will argue that it has also produced landmark outcomes.
There's no doubt about that, Jumai. Now, the political spectrum that used to be defined largely as a two-horse race will certainly not be the same again. And the emergence of a third, and if you may, a fourth force is historic. And that's in addition to other numerical and demographic variables that shape the elections of February 25, 2023.
And while the governorship and House of Assembly elections are a matter of days away, the presidential and National Assembly elections have been conducted and winners have been declared. But a sore point is post-election litigations, as aggrieved political parties have indicated their interest to challenge the election results in the court.
Well, the Labour Party drew, as it were, the first blood, stating that it will rig out of the elections by annexing ability to upload results from the polling units as promised. And then the People's Democratic Party, PDP, also said that it won the elections. But the good thing is that both parties have resorted to abide by the rule of law by approaching the election petition tribunal in the first instance, while also appealing to their supporters to remain calm and peaceful.
And as we said earlier, election litigations are bound to happen in any election cycle. And reports indicate that the courts are already inundated with pre-election cases, not to mention now that we are likely to have a litany of post-election cases.
Well, the Chief Judge of the Federal High Court, His Lordship John Soho, said last December that there were more than 1,800 pre-election cases seeking attention. And the Court of Appeal, which has statutory responsibility of coordinating post-election litigation, itself also has over 600 appeal cases arising from pre-election matters.
Well, it is better to slug it out in a court of law than resort to violence or self-help. Election litigations are not necessarily bad, but are expected to bring about redress of perceived electoral malpractice and not replace the sanctity of the ballot. So what are the benefits and challenges of election litigations? This is the thrust of our conversation on Good Morning Nigeria today. I am Juma Yusuf. Welcome you to the program.
And I'm Kingsley Osadolo. I join my colleague Jumai to also welcome you to the program. We're live on the network service of the Nigerian Television Authority, broadcasting from our headquarters studios in Abuja. Jumai, we're talking about the global phenomenon of election litigation. We find that pretty common on the African continent, but it's also not uncommon in the United States.
No.
Yes, it's, we remember the famous litigation following the 2000 presidential election in the U.S.
Al Gore and Bush.
Yes, and Bush the son. And it took the Supreme Court decision 5-4 split to uphold the election, following, of course, the complaints
Florida,
about what happened with regard to the hanging charts in Florida. I had the privilege of being in that county some years later, and we saw the samples of the hanging charts and how difficult it was to read exactly whether they were valid or invalid votes. But that's the issue. We'll be taking a look at, it looks like increasingly our elections end up in courts, and the courts, many would argue, now seem to be deciding who the winners are rather than the winners emerging directly from the ballot box. Once again, welcome to Good Morning Nigeria. And in the course of the program, we have our business and newspaper review. For now, here is Nolile Belame, who has the highlights of the morning news. Good morning, Nolin.
Good morning, Kingsley. Good morning, Jumai. Good morning, Nigeria. Here is the news. The state of Qatar has announced a $60 million contribution in demonstration of its firm commitment towards supporting the development process of least developed countries. The Emir Sheikh Tamim bin Hamad Al Thani made this known in Doha at the opening of the 5th UN Conference on Least Developed Countries.
It's partnerships, that we're all as strong as our weakest link. And so if we put in place global mechanisms to strengthen and support least developed countries, everybody gains.
President Muhammadu Buhari has called on leaders of the various Chadian political factions to show restraint and patriotism by immersing themselves in the ongoing transition to democracy in their country. This was when the country's transition president and head of government, General Muhammad Idris Deby Itno, who visited him on the sidelines of the ongoing UN conference on the least developed countries in Doha, Qatar.
He briefed Mr. President on the efforts that they were making to stabilize the situation in Chad. He said that there are about 50 military groups, political groups, and that out of the 50, 40 of them have now joined the peace process, transition process, that there were still 10, and that, he's still talking to them, and hopefully they will soon join the transition process.
Similarly, Minister of Foreign Affairs Jeffrey Onyema has restated calls for Nigeria's inclusion into G20, including other AU member states. The minister made this known at the just concluded G20 Foreign Ministers meeting in New Delhi, India. Addressing the G20 Foreign Ministers meeting, the Minister of Foreign Affairs indicated Nigeria's interest of becoming a member of the G20 in the nearest future. Also, the minister called for other reforms in the United Nations and its agencies to effectively confront global challenges. And back home, Methodist Church Nigeria now has a new Archbishop of Abuja, and he is the Most Reverend Michael Akinwale. Vice President Yemi Osinbajo, who witnessed the enthronement, advised the new Archbishop to let his voice be heard and his leadership seen everywhere where there is injustice, deprivation, or lack.
Sat you on the throne. I know that you are not blinded by the pomp and pageantry of this great occasion, but that you see this as a call to the service of God and man, and a responsibility of awful moment in our troubled country and our troubled world. Indeed, the office means that your voice must be heard and your leadership seen where there is injustice, where there is deprivation or lack.
In other news, NNPC Limited says there is a robust plan in place for the supply of petrol from mid-February to March 2023. Latest updates released show that NNPC Limited has a total of 1.8 billion litres of petrol stock, while for March 2023, a total of 2.3 billion litres of PMS is expected into the country. Another 2.5 billion litres, which is equivalent to 42 days sufficiency, will be the closing stock for the month under review. Chief Corporate Communications Officer of NNPC Limited, Garba Muhammad, in a statement, assures motorists that there is sufficient petrol in the country. The Nigeria Midstream and Downstream Petroleum Regulatory Authority, NMDPRA, assures Nigerians that operations in loading depots have fully resumed following the restriction of movements during the recently concluded presidential and National Assembly elections, which necessitated truck drivers to travel to exercise their civic duty. Consequently, the NMDPRA is working with other stakeholders to mitigate the slight tightness being experienced in the distribution of petrol PMS. A statement by the authority's chief executive urges the public to note that current stock sufficiency stands at about 40 days for PMS, 35 days for AGO, and 32 days for ATK. The authority strongly advises against panic buying. On security, normalcy has returned to Maru town in Zamfara state after a terrorist attack on the community, which led to the death of the divisional police officer in charge of the area, SP Kazim Rahim, and a police inspector, Rabiu Umar. In a statement issued by spokesman of the Zamfara Police Command, SP Muhammad Shehu, the unfortunate incident happened early yesterday morning when the terrorists, in their numbers armed with sophisticated weapons, attacked the division with the intent to destabilize the security architecture of the town in order to abduct some members of the community. The statement says the victims paid the supreme price as they gallantly tried to repel the attack. That's the news for now. Good morning. Nigeria continues with...
You're still watching Good Morning Nigeria on the network service of the NTA. Business News is next with Alika Okbanachi Arua.
Exporters of processed woods have intensified efforts to reap from the exportation of the products, with a market value put at over $152.94 billion for the year 2023, following the recent lifting of ban for its exports by the federal government. They are also targeting the exportation of charcoal, with a current market value put at over $5.41 billion, respectively. The government has conditionally lifted the ban on charcoal and processed wood exports in a bid to revamp businesses, especially those converting waste to wealth, and thereby increase the country's foreign exchange earnings. Minister of Environment, Mohammed Abdullahi, disclosed this in Abuja at a stakeholders consultative meeting on the review of the ban on charcoal and suspension of processed wood and other allied products. Abdullahi said the ministry has observed that many businesses have been unintentionally affected, especially those converting waste to wealth for exports by the ban. He, however, cautioned operators in the industry to adhere to the Nigerian timber legality standards and guideline for wood and charcoal exports to avoid persecution, as the decision to lift the ban could be revisited by failure to comply with the laid down rules and regulations. With Business News, Alika Okbanachi Arua.
Thank you very much, Alika Okbanachi, for the business package. Coming up next for us now is Newspaper Review.
newspaper reviewer Chukwudi Okoli-Ogbaja is in the studio. Good morning.
Good morning, Jumai. How have you been?
Fine.
You look crisp and shiny from weekend effects. Good morning, Kingsley.
Good morning, Chukwudi.
How are you doing?
Very well. How was your weekend?
Oh, lovely. I bounced around. There wasn't a lot of money in my pocket, though.
Nobody has money.
We thank God for small mercies.
Exactly.
You bounced around like a football?
You're not talking football. What happened over the weekend?
I'll give him 7-0 if he doesn't take care.
You bounced around like
Liverpool. Anfield smiled dangerously.
Oh, my God.
You never seen such a dismantling of Manchester United.
Of all clubs.
Oh.
It was unbelievable.
It was unbelievable. It was a spectacular performance by Liverpool. You had 3 players, each of them scoring a brace, and then Mo Salah from Egypt, now becoming the highest EPL goal scorer for Liverpool.
Yes.
Certainly, it was a stunning defeat for Man U. And to imagine that Man U only a week earlier had won the Carabao Cup against Newcastle, and Liverpool itself had been struggling, as it were.
Oh yes,
in the middle part of the previous.
But we are just 3 weeks, 1 month ago. I pitied Ferguson yesterday. He looked miserable.
Absolutely.
This wouldn't have happened in my era.
How much should he be sitting down in the stadium watching live football anymore? He's getting too old.
But you know, the thing is, Manchester United had suffered such humiliating defeats in the past.
Yeah.
But you have to look back to a period long before Winston Churchill became British Prime Minister. The last time they were
79 years or 97 years.
No, 92 years.
92 years.
The last time they were hammered was by Wolves in 1931. 7-0. So a record that Liverpool said. And when you watch a great match like that, you have a delightful weekend.
And then you forget that you don't have money in your pocket.
Precisely. That's why I said we were bouncing like a football. And you also have to praise the current league leaders in England. Yes. I'm talking now about Arsenal.
They were 2-0. Don't throw it far away. You're talking about
Ghana for life. Ghana for life.
There were 2 goals.
You're talking about the youngest team in EPL.
Absolutely. 2 goals
okay,
down.
let's quickly.
And then hang on a second. We're going to the newspaper review. 2 goals down, and they came back 2-1, 2-2, and then 3-2. Look at that blast of
the tough champions are made up.
But I tell you, assuming Arsenal were at the receiving end of the humiliation by Liverpool last night, no, by today, and everybody will say, look, just disband Arsenal. I agree with that. That's right.
Well, that's why we're Gunners for life.
We're perpetual fault finders in Arsenal. I don't know why we are like that.
Well, let's quickly go to the papers. We begin with the Daily Sun newspaper, just by the side piece of the masthead. Atiku to INEC chair. Your promise of credible gubernatorial election medicine after death. With a rider, Commission should review presidential poll results declaration as provided by law. That's coming from the TAAGG, that's tag. And just below the masthead, U.S. opens up on February 25th polls. Says whole electoral process failed to meet Nigeria's expectations and backs desire for responsive and inclusive governance. Down the picture story there, you see Ayu Okowa lead black uniform protest at INEC headquarters today. Commission, APC arranged presidential poll. Igbo lawyers allege. You find that on page 27. Side piece of the picture story, petrol scarcity returns to Abuja. It will soon be over. That's coming from the NNPC Limited. Yoruba monarchs urge Tinubu to use victory for Nigeria's unity greatness. You find that on page 6. Enugu Gabo group threatening mayhem sponsored by politicians. That's coming from IPOP on page 5. G20 minister calls for Nigeria AU inclusion. UNSC, IMF, World Bank reforms. You find details on page 26. Naira redesign, confusion as CBN keeps mute over Supreme Court ruling. With rider, businesses, transporters reject old notes. At the bottom plate of the Daily Sun, Oyo Grabo, LP candidate, party escorts fall apart over adoption of Makinde. And the picture story we see there, Vice President-elect Kashim Shettima during his condolence visit to the former head of state, to the wife of the former head of state, Sani Abacha, Hajia Maryam Abacha, over the death of her son in Abuja at the weekend. Let me quickly go to the leadership newspaper, Kingsley. Above the masthead, resist injustice, serve Nigerians, or Shimbajo tells clerics. Gunmen kill DPO, village head in Zamfara, Kanu. You find the details on page 10 and page 13. And below the masthead of the leadership newspaper, FG can generate 10 trillion from fuel, forex subsidies removal. Find the details on page 8. PNB urges Chadian factions to support transition program. Find also the details on page 8. At the side piece of the picture story you see there, rejection of election results by politicians, not new. That's coming from Yakase. Naira redesign, direct CBN to obey Supreme Court order, Sarah tells PNB. Obasanjo blames politicians for food crisis in Nigeria. Details on page 10. And the headlines is coming from the lobbying for appointments in Tinubu's presidency begins. And with riders, women want 50% slots. Give us FCT minister, natives tell president-elect. Northeast leaders call for broad-based government. And serve all Nigerians who voted for you, Ekiti APC. Leslie?
Okay, we also have the Punch newspaper, and I'll take some of the headlines. The others that you read from the other papers, I will skip. Above the nameplate says Akpabio, Kalu, and others begin battle for Senate presidency. That will be the 10th Senate. Fuel and FX subsidies removal will save federal government 10 trillion naira, according to a report. Observers demand Rex prosecution for alleged sabotage. Details on page 42. Prepare for severe flooding, NEMA warns Nigerians. And presidential poll, PDP governors and leaders to protest at INEC today. PDP insists election flawed, APC urges peaceful demonstration. Residents fear unrest and hoodlums hijack, police promise protection. You see the photograph there on the front page. Tinubu visiting Oba Akiolu of Lagos and promises not to disappoint Nigerians. The Oba is in the middle there. Tinubu, president-elect, is on the left. The governor of Lagos is on the right. The governor of Lagos is also helping to hold up the certificate of return that the president-elect received from INEC. The governor has a battle on his hands this weekend in the governorship election in Lagos.
Quite a battle, actually.
All right, so, Chukudi.
Yes, please let me quickly say PDP has said it's going to court. The protest aspect of it, I don't quite understand. What is it all about?
They protest the election results.
When you have said you're going to court, they don't quite go together in my mind, you know, but then they have the right to do so, and I'm happy that APC recognizes that PDP has the right to protest. They are urging them to please make it peaceful. And the police are saying, we'll give protection. You see, I always like to see the good sides to all these things people call crisis. I see us moving forward. That is a good one. Now, the PDP had said it's going to court, so one would have expected them to follow that route strictly. But maybe their lawyers have advised them that you need to also work on the people psychologically. It's just that court cases are not decided by the public. So ultimately, it is the men in those, wigs that sometimes frighten me, that are going to have the last say. So, if they're going to protest, let them protest, but let us make sure that the wonderful management of the post-election period we have seen so far is something we should all commend on behalf of our country, Nigeria. It is very important that we stick to that. Order should be the order of the day, so to speak. Okay? I am frightened by the return of fuel queues to Abuja and other places as supply dips. And you want to add a rider to that. This actually is fuel queues return to Abuja, other places. And I'm saying you want to add a rider. No, not again,
Well, they say it is because tanker drivers went to exercise their franchise at home. That's why we have the fuels.
I don't know why people say things that don't quite define us as people who are ready to tackle things that sustain life. How could tanker drivers observing Salah, tanker drivers going to exercise to vote become the reason? You're talking about something that happens for just 1 week. It doesn't quite tell you that we are tapping into our stock properly. Exactly. If the stock is there. If the stock is there, And they are saying that the federal government will be saved 10 trillion naira if subsidies on foreign exchange and fuel get removed eventually. And I am asking, is it a promotional story to ready us for removal of these subsidies, or are there really gains to be derived from the removals? I'm sure Good Morning Nigeria will get experts to discuss this at length anyway.
Yeah.
Well, this is newspaper review, so I'm more interested in how the media ready or readies, depending on whether you treat it as singular or plural, the people, to be part of discussing the proposed, already the provision made for subsidy is going to end in May. So technically, by June, the subsidy would disappear, of his own accord, so to speak.
Well, so we begin to face reality.
Yes, we begin to face realities. They are adding, foreign exchange to the proposal, and I'm thinking, is this going to help Jumai maximize whatever he gets in front of Sheraton when she gets those dollars from a few friends in
You have started again. I don't want kids to start saying I have $1 billion in my house.
Is that the way you want to hide the fact that you have $1 billion in your house?
Amen to that.
Okay, before we sign up, there are one or two issues I want to draw attention to. Okay. One is the story on the front page of the Punch here that says observers demand Rex prosecution for alleged sabotage. Do you have the details on page 42 of the Punch? And it is the Center for Transparency and Advocacy that is demanding that some RECs, that's the resident electoral commissioners, electoral officers at the local government areas, supervisory presiding officers, and dubious ad hoc staff, and all those who were involved in electoral malpractices should be arrested, prosecuted, and punished to serve as a deterrence to others. And I think that this is a welcome call. Attention has been focused largely on the chair of the Independent Electoral Commission to say, oh, you failed Nigerians. But we know that it's a system. So if there were lapses, where did those lapses occur? If there were compromises, where did those compromises occur? How did they occur? It is when a country chooses to find answers to such queries, yes, and to hold people accountable, yes, for either their negligence or their deliberate actions that conduce to the malpractices in the election. That is when you make progress. That's when it is not sufficient to say, oh, you make a generalized statement, oh, we are looking into it, and then everybody goes say, those who have committed the offenses, those infractions, they will be hiding under the canopy that you have given under your generalization. So, exactly, where did these glitches occur? INEC itself might not administratively be in a position. Will it then require the establishment of a panel, of a special panel or a committee to investigate the conduct of the proper investigation? Yes. And then be a boss. I'm not for a panel of inquiry because the federal government doesn't have that authority. But it's a panel. Who's going to set it up? Is it INEC itself? If it's INEC itself, if INEC does, then that would be an indication that it is ready and willing to get to the root of the matter. Because the dismissive statement by Atiku, that's the former vice president and candidate of the PDP, that the pledge now to conduct good governorship elections is medicine after death. So when you needed the medicine, Nigerians apparently didn't get it. Now, who was it that was negligent
very important.
You must attach that responsibility. There must be accountability. There must be penalties.
You know, Kingsley, in 2019, when some of the parties went to court, I screamed in my layman's contribution. What about those people we saw overturning ballots in Lagos and some places, burning up? Somebody told me a judge does not, give what is not asked for. How do you put that?
Yeah, that's right.
Impunity. Yes, the impunity is just something we should not stomach anymore.
Yes.
I hear that it's time to go. So let me.
We'll sign you off, Chukudi.
Yeah, we're signing you off. Well, sorry, I said two issues. That's one. We're not going to sign you off. Last Friday, the Supreme Court gave its decision on the Naira redesign policy. We're not going to have time to discuss that. Hopefully, tomorrow I have my comments on the decision, because the more I speak, the more issues, of course, more windows will open up for other topics. So we'll take a look at it and then see what happens. We already read a few headlines from the paper saying people are rejecting.
Yes.
So what does that tell you?
It's okay.
Well, Chukudi, thank you so much for coming.
As I expected the Supreme Court decision to be obeyed.
Of course, yes.
Thank you.
We'll take a break. When we return, our conversation on election litigation will begin. Do stay. You're watching Good Morning Nigeria on the network service of the NTA. As a prompt for our conversation, which is on election litigations, here's a background report by our correspondent, Abdusalam Jibril.
That Tinubu Bola Ahmed of the APC, having satisfied the requirements of the law, is hereby declared the winner and is returned elected. Thank you.
The Independent National Electoral Commission, INEC Chairman, Professor Mahmoud Yakubu there in the early hours of 1st March, declaring Bola Ahmed Tinubu of the All Progressives Congress as winner of the presidential elections after results were collated from all the states. Election observers maintained that the polls were largely peaceful, regardless of pockets of violence witnessed in a few areas. However, reports of voter intimidation and attacks on some polling units from which the bimodal voter accreditation system BVAS machines were stolen, notwithstanding the bone of contention revolved around the alleged failure of INEC to upload polling unit results to the INEC Result Viewing IREV portal on election day, as previously assured and guaranteed by INEC. President Muhammadu Buhari, President-elect Bola Tinubu, some elder statesmen and international observers, among others, have urged any aggrieved person or parties to go to court rather than incite the public to cause mayhem or public disorder. So far, the People's Democratic Party (PDP) and the Labour Party (LP) have opted to challenge the 2023 presidential election results in court, while urging their supporters to remain law-abiding. While some analysts note that post-election litigation in Nigeria's electoral process has become a norm, how will the courts effectively handle the barrage of post-election cases before it? Guest on the program will be speaking to election litigations shortly.
Thank you very much, Abdusalam Jibril, for that background. We have with us in the studios here Oluwole Osaze Ozi, a legal practitioner and election expert. He's also a former director of legal services at the Independent National Electoral Commission. Osaze Ozi, we're glad to have you this morning.
It's a pleasure. Good morning.
Thank you. And joining us from our Port Harcourt Network Center is a constitutional lawyer, Chief Festus Oguche, a regular guest on Good Morning Nigeria. Chief Oguche, we're glad to have you this morning.
Yes, thank you very much. Good morning, Nigeria.
And from our Kaduna studio, we have joining us another legal practitioner, Yunusa Ustaz Usman, Senior Advocate of Nigeria. Thank you so much for joining us.
All right, I'm sure our engineers will sort out the audio connection there to our Kaduna Network Center. Once we get the all clear, we'll return to the Senior Advocate Yunusa Ustaz Usman. And just before we bring in Ustaz Uzi, of course, for his first comment, our focus on election litigation relates not just to the aftermath of the election itself, but usually pre-election matters. You have a deluge of cases on pre-election matters, and after voting itself, you also have petitions and appeals arising from those petitions. And it's to anyone who is not directly interested or affected, interested in or affected by these elections. After a while, you have difficulty just keeping track of what is happening. Sazeozi, give us a sense of it from your experience as Director of Legal Services of INEC in the past. What it means to be grappling with this multiplicity of cases, pre-election and then post-election.
Thank you very much. First of all, I think everybody, every Nigerian citizen is impacted directly by the outcome of the elections and the resultant litigation that almost always follows the process. It's part of the process. I think it's said, first of all, that litigation, electoral litigation, is a welcome development in the sense that if we're practicing democracy, the tenets of democracy includes the rule of law, and the recognized way of settling electoral as well as other disputes is through the legal process, through litigation. ADR, alternative dispute resolution, is increasingly becoming an important part of the legal hierarchy in terms of settling disputes. But in the Electoral Act, right from this inception of this regime, has recognized this dispensation has recognized electoral litigation, election petition, as the number one, the main way of settling election disputes. And people support that in the sense that it's better to have that than to people go to the streets. I saw in the Punch newspaper reporting and newspaper review, for example, that the PDP was going to march on INEC, for example. That's one way. People are allowed to congregate, people are allowed to go, but you know very well that things can go out of hand. The NSAS debacle is one of those recent instances in our memory, just 2-3 years ago, where the ideals by those who organized the protests were hijacked by others. So things can go out of hand. So that's why we always say, look, litigation. But having worked in the commission, I think this cycle is almost unprecedented in terms of the fact that I was in court a couple of weeks ago when one of the justices of the judges in the Federal High Court said that they had more than 700 pre-election cases to deal with. And every legal practitioner who practices in this jurisdiction will tell you that in the past couple of months, the Federal High Court, which now has exclusive jurisdiction to deal with intra-party matters, has been the deluge. I think that's your word, and it's about the most appropriate word. The deluge has choked the dispensation of justice system that hardly any other matter has gone on in the Federal High Court in the last couple of months. Hardly any other case apart from pre-election cases. And the irony of it all is that two things. One, we wanted part of the proposal for the reform, and prior to now, all the high courts, High Court of the FCT, High Court of the State High Courts, had jurisdiction to hear all these matters. But that is one of the innovations of the Electoral Act of 2022. It removed jurisdiction of those other courts, the High Court of the FCT, the High Court of the State High Courts, and left it exclusively with the Federal High Court, in the hope that there will be more consistent decisions. The principle of stare decisis, the principle of following previous decisions will be more strictly adhered to, and there will be more direction, more purpose, and streamlining these cases. One, it did not decrease the number of even with all the reforms as well, it did not decrease the number. On the contrary, a lot more. The Court of Appeal, the same thing, because almost all of these cases end up in the Court of Appeal and possibly in the Supreme Court. I know that for the past 1 month, Supreme Court, every day you go there, the court is choked with more than 10, 20, 25 Supreme Court cases. Don't forget, there are about 8 or 9 justices of the Supreme Court presently. It doesn't have its full complement. And because of that, you can hardly empanel 2 panels. Because otherwise, if there are 20 justices of the Supreme Court, for example, you can do 2, maybe even 3 panels. They have courtrooms for where they could sit. But now you have 1 and overlapping justices, so you have less than 2 panels that hear these matters. Nothing else goes on. Human rights matters, serious commercial matters, criminal matters, death sentence matters, capital offense cases are all being adjourned. And not just adjourned for 1, 2, 3 months. Adjourned for, in some cases, I'm not exaggerating, for years. There are motions that we have in the Supreme Court that have now been adjourned for 2 years. Some of them are very critical, some of them are very important. So that's that. And again, that's from the judicial angle of things. For INEC is joined as a respondent in all these cases. It just cannot cope. There are not enough legal officers, quite a number of legal officers, competent, good people, but they just cannot cope with the number of cases that they have to handle. So very often you go there, admittedly, INEC is usually a nominal party, but it has to follow proceedings because it will be bound by the orders made by the High Court. Because when the petitioner, when the claimant joins the INEC, don't accept this man, accept me as the genuine candidate. I was wrongfully substituted, or I won the primaries and things like that. So a lot of energy, a lot of resources are dedicated, both from the administrative, the executive, that's the INEC perspective, and then the judicial perspective of work. A lot of things. So the system is choked. And any system that is choked like that cannot be as efficient, cannot dispense justice properly and the way it should be. So the reforms haven't helped things, sadly they've worsened things. So you have to balance the need for people to take the legal route for settling their political disputes. You have to weigh that as against the pressures on the system and how other areas suffer as a result of it. It's opportunity cost, as the economists will say. One gives way for the other. Something must suffer.
So what is the way out now out of that situation we find ourselves?
Wow.
Is the judiciary overwhelmed?
It is overwhelmed. I was looking for that word. The judiciary is overwhelmed by these pre-election cases. Pre-election cases, and just before you complete the pre-election cases, because, again, the problem is that there are time limits to determine these cases. So because of the priority given to these cases, every other thing suffers. And in the High Court, the first instance stage is 180 days, 6 months. And the next, I remember one judge had 80-something cases. He was the only judge in a particular judicial division of the Federal High Court. He had 80-something cases to deal with in less than 6 months. It's impossible.
Okay, thank you very much, Osaze, there for your opening comments. Let's go over to Festus Oguche in our Port Harcourt studios. Festus Oguche, you listen to Osaze. Let's have your take on the role, as it were, of the courts in determining, as it also, outcome of elections, pre-election and post-election. It just creates uncertainty, as some persons will say, let's wait. You are giving somebody congratulatory messages. You don't know whether 2 days down the road, another person just might be declared winner of the election. What does this do to our electoral jurisprudence? Well, Festus, it looks like we're not having a connection to you. If Leland Senior Advocate Yunus Ustaz Usman in our Kaduna Network Center, if he picked that up, I would like him to respond to this. That's to say, some persons are getting concerned about the role of the judiciary in determining, as it were, the outcome of elections. Not particularly a Nigerian problem, but at least in our national circumstance, persons are getting worried that more and more electoral outcomes are being decided in the courts rather than the electoral ballot.
Thank you very much. You see, my few years of doing election petitions from 1983 to today is that these things are caused by want of sincere leadership by the politicians and the political parties. That is just the cause. It is not the court. And I tell you why it's not the court. The court and the lawyers stand by. After their dirty games, they will now call in the court and the lawyers and start blaming the court and the lawyers. It is just like trying to convict a conductor for the accident of the bus driver. But let me tell you the little history about this, the election court cases in particular. It started in 1843. And then the issue used to be that even the municipalities and so on, if they knew that they were going to lose an election, the richest ones will hire warlords, people who use guns to fight for them. Later on, they decided, they said, look, this thing is not helping us. At the end of it, will be extinguished. So they now decided to take their war to the courts. And that is how the judiciary and the use of lawyers came into existence. So it's a good development for the law, a good development for election. That is, instead of taking up arms, you now have adjudicators. That is how far that goes. But I'm telling you that from my little experience, since Unongo and Apaku in 1983, it is want of leadership, want of effective political system, and the insincerity of almost all politicians from then till now, quote me, that is the cause of all these things. And unless our politicians now develop sincerity of purpose in election matters, we will continue to go about this. And the courts, initially, I was one of those who had always delivered papers that there should be no special courts for election matters. But the way things are now, there is the need for it now because the courts can no longer cope up. There are too many. And you see, don't blame those who go to court. Like I said before, it's because the political parties, the leadership of the political parties, there is no internal democracy with the political parties, particularly the heads. So whoever is cheated thinks, and rightly too, that the only way he can ventilate his anger is to go to court. And of course, that is better than taking up arms. That is why we have this. In fact, we had almost 8 pre-election matters. Some are still pending. And there's just nothing you can do. Fortunately, the Constitution, particularly Section 285, now fixes the time within which to conclude these matters. But sometimes it is humanly impossible. You can't just complete them. And the only way out, like you may ask, is to create special courts. Call it constitutional and election petition courts. There is need for that now. For instance, the other time I was in the Supreme Court had 26 appeals on pre-election, 26. 9 people. And they had to deliver the judgment, and they did in a week. I mean, are you killing them? That is the starting point from it. But let me tell you, unless our politicians learn how to do politics, unless they learn to establish internal democracy, justice and fairness, these things will continue to rise daily. Maybe after those of us who are old are gone. To it in sight as at today.
Thank you very much, Senior Advocate Yunus Ustaz, for your opening comments. As you indicated, you have had a short spell, as it were, in election litigation beginning in 1983. A short spell of 40 years, I'm sure that...
and you said it's a few years.
So that's quite interesting there. Thank you very much for your modesty. Of course, we'll return to you in the course of the conversation. First, also, Guche in our Port Harcourt Network Center.
I hope it's ready.
I hope you got my question before we lost contact with you. In terms of, as it were now, the recourse to litigation in order to settle electoral outcomes. What is this doing to us?
And the way the judiciary operates now is like
it's a pre-election. Sometimes it is for the judges to attain that level of accomplishment to giving justice. From our own politician, the desperation class to political office very, very because they can, and also the fact that the process by errors and flaws of fraud. If you want to get the election right and get the courts to take proper decisions, then we have to sanitize the things are important. And also when we get into the proper litigation, the courts must be a tandem.
We seem to have a problem with Port Harcourt, but I'm sure they will get it right in due course. Coming back to the studio, Mr. Osenze, you know, they say when you go to the courts, you get justice. And these litigations goes back and forth, back and forth, back and forth. 600 pre-election cases, and now the presidential cases again, and we are going for state elections soon. You know, experts say it can erode the confidence of the common man in the power of judiciary to give them justice. What is your take on that?
Well, you left one stream of cases that are likely to come on board, that for the National Assembly.
Yes,
and don't forget there are
360
House of Representatives seats for grabs in this last election, and 109 senatorial districts, and there are 18 political parties. Even if half, and let's not concentrate too much on just the presidential. The presidential is just one, and it goes straight to the Court of Appeal. It starts from the Court of Appeal.
Like, for example, now the state election, governorship, 18 political parties, more than 837 candidates, and more than 10,000 candidates for the State House of Assembly.
Correct.
That is just...
It's huge.
It's huge, yes.
Well, we have designed this. The architecture of our system is such that any political party that participates in an election, or any candidate, or both of them, are free to go to court to challenge the outcome of any election. That is the architecture of the electoral ecosystem. So that's the way the legal way of challenging outcomes of elections. In a democracy, there is no better way of doing that one. People have advocated for alternative dispute resolution and other things, but as Yunus, senior advocate, said, there's a desperation amongst the people, and they don't think they can get justice in any other way apart from election litigation. It overwhelms the judiciary, and there's the quantity is bound to affect the quality of outcomes. It's only natural, because one person doing, say, 10 cases will handle a case a lot more efficiently than if he was to handle 50. The quality of judgments, the quality of rulings certainly will drop. So in that sense, but these courts will still try to do justice. A lot of these cases, one must add, or quite a number of them, ought not to have seen the light of day, ought not to have been filed in the first place. You know, you won't believe the kind of, let me take the presidential, you won't believe some of the kind of cases that were involved. There are more than 10 cases I'm aware of trying to stop one candidate or the other from contesting the election. There was one particular case where the PDP, NNPP, Labour Party, and APC were sued in one case over placeholders and the rights to substitute candidates. There was a case where a political party took another political party to court and said, look, your candidate obtained the honorary citizenship of a city in the state in the US, and as such, it should be disqualified. Somebody took that to court. Now, how does the Supreme Court deal with this? Being the final arbiter in the case, it encourages you and say, look, what are the issues? It cuts the chase. What are the issues? This thing says you should file it within 14 days, for example, of the occurrence of the event complained about. When did the primaries take place? It took place on such a date. Now, this is if you filed when? 17 days later. Why should we go? We've done more than 20 cases about cases being statute barred, and when interpreting that particular section of 285, for, why should we waste our time and resources to deal with this case? Counsel, what do you want to do with this case? Well, you could be stubborn enough and say, I want to proceed, in which case, fine. They'll take you up on it and then probably give their ruling on their judgment, in which case, often they give costs against the counsel, personally against counsel. Ordinarily, it is the parties that pay the costs. But this time, they give costs against counsel. And it's not like normal civil cases where they give 10,000. In the meantime, you spend 10 million naira. Now they give humongous costs against counsel, to be paid personally by the counsel to each set of respondents. That is one of the creative ways that the Supreme Court has tried to, and it does a lot. Yosa is quite right. More than 26 cases. It's not unusual in the last 2 months to have more than 20 cases on the Supreme Court's cost list. The Supreme Court can only deal with, first of all, only the most important, most fundamental cases should go to the Supreme Court. In the Supreme Court in England, former House of Lords, you must seek leave in almost all cases. And the masters or the Court of Appeal just tell you half of the cases don't proceed. We've given a judgment. We don't think that this is the kind of case that is deserving of going to the Supreme Court. In the US, the same thing. Most of the mature democracies that we take after, it's only the most fundamental of cases that end up in the Supreme Court. But here, just about, you'll be surprised at the kind of cases that end up in the Supreme Court. And very often they say, look, counsel, advise your lawyers. Counsel, advise your clients. Make sure you advise your clients. This is not the kind of case I should bring here. If it doesn't take heed to your advice, then leave the case. But counsel should not be filing this kind of cases. That's why, in anger, the Supreme Court said, look, you should know better. And so we get to you personally, not your clients. As to confidence in the judiciary, I think those people have confidence. That's why they're there. Admittedly, there are some cases that have come up recently that, for the average Nigerian, beats the imagination. A case in point where a person doesn't come first, second, or third, and you declare him governor of a state. I guess they have looked at things, and from what they have presented to them, because that's one thing you should realize. I think it came up during the newspaper review. Courts and justices determine cases based on the evidence before it. That's why a lot of spleen is being vented in the social media now. And I saw one call by one of the political parties and said, please, these are the numbers, these are the WhatsApp numbers, whatever evidence or video you have, upload them to us, which is excellent. Because this case will not be fought and won on the social media. So very often, the media, especially social media, determines cases even before they come before the courts. So you don't know what evidence they have produced before the court. And because social media is a very dangerous place, a lot of fake news is on social media, and all the observer reports, that's part of what they realize. So you are predetermining outcomes of election disputes on social media. Whereas when you go to court, a lot of these things don't come before the judges. Well, the judges cannot use social media as a basis for entering a judgment. They must do it based on demonstration of the evidence and facts adduced before the court, subject to cross-examination by the opposing party. Because there are times you bring things, by the time you cross-examine people, you find out that this thing is not what it appears to be. You don't have that opportunity on social media.
All right. Sazeozi, thank you very much there for your explanations. Let's return to Kaduna Network Center. Senior Advocate Yunus Ustaz. One of the issues that Sazeozi raised in his response has to do with the apparent frivolous nature of some of the cases under our election litigation. It's also indicated the steps being taken by the Supreme Court now, where there's an abuse of court process or a matter of litigation that ordinarily shouldn't have been pursued by the advocate, that the Supreme Court now, of course, imposes costs to be paid personally by the attorney. Some persons have raised two perspectives, and this is, of course, with the greatest respect to lawyers who are involved in election litigation. That one, it's almost like any brief that comes to you, take it, and then you also encourage clients to come with briefs. Because briefs of this nature are not on a pro bono basis. You pay for them. That's one. And secondly, some persons have also argued that it's now becoming one of the easy access to accumulating appearances before the appellate courts and ultimately the Supreme Court, and thereby boosting the chances of a lawyer in being admitted into the inner bar as a senior advocate. What are your thoughts?
Thank you very much. You see, like my brother Osaze has said, one of the ways the Supreme Court is trying to curb these unnecessary appeals is by awarding costs against the lawyer, particular lawyer handling the case himself. And it's very is very effective. The issue of your trying to amass cases or trying to be SAN, I think it's a great mistake we make. I have this belief, and I think for me it works. Whatever brief is yours, even if you are in the cave, it will be brought to you. I have no chambers in Kaduna, but by the grace of God, I have over 30% of the cases from Abuja. So why are you rushing after cases? What is yours? God will bring it to you. You don't need to run after cases. Just make sure that you don't deceive your clients. Make sure that you advise them where they have bad cases, and if they have terribly bad cases and say you should do it. Look at the technical aspect. If there is no technicality, strong technicality you can hinge onto, please reject the cases and their money. God will bring you your own, and they will respect you more. If it is for you to accumulate cases to become SAM, you accumulate the cases. If God has not ordained you to be one, how are you sure you won't die before then? How are you sure you will get it? That is that one. But I'm telling you, the issue of the congregation of courts, please, I've been saying it, and I drum it again. And my brother Osaye gave the example of UK and particularly USA. Our constitution is modeled on the USA model. But the way they congest their own courts is simply this. Every state has up to High Court, Court of Appeal, and Supreme Court. Every state. And in such a case, it is only cases of utmost constitutional importance that go to the Supreme Court. Unless we do that, even if you appoint 900 more justices of the Supreme Court, our courts will not be decongested, because litigation is the only way out. And to me, every political case, every constitutional case must go up to the Supreme Court. Unless you have this, the courts cannot be decongested. And when somebody attacked me the other time, I said, where is the money? It is because we are misplacing the use of the funds. This money you pay to the governors as security votes. What do they do with it? When there is problem, is the federal government, like of recent, is what who has been paying for flood and the rest of them. Use this money. Each state can establish its High Court, Court of Appeal, and Supreme Court. Don't tell me Nigeria has no money. We have money. The only thing is that our monies go into private pockets. So there is misappropriation of our priority, and that is just that. Appointing more judges will not solve this problem. And the issue of the court being the last hope of the common man, whether you like it or not, among the three arms of the government, as far as I'm concerned, is the judiciary that is the most dependable. Sometimes we misinterpret the Supreme Court judgments and so on. The social media will unless somebody reads the judgment, you know why the Supreme Court might have come to that decision. There was a recent one. They say, somebody will not contest this. After reading that judgment, I now understood. And Supreme Court did not say, bring this person. The Supreme Court said that case you filed was not properly filed, and struck out the case. But the social media says somebody who did not win election, somebody who did not contest this. You see, I'm begging the third realm of the constitution that please, before you go to the press, make sure that you have a copy of that judgment and read it. And sometimes what we notice too, when we are in court, some of the journalists you send do not even understand what is going on in court. When you come out, they will not say, what did the court say? So it becomes hearsay. And that's why we're having all this problem. But please, if you want to stabilize Nigeria, don't report any case until you might have read the judgment. Please.
Ustaz Yunus Hassan, thank you so much there for your comment. I hear that Port Harcourt is ready. Chief Festus Ogocheri, are you ready? Can you hear me? You've been listening to this conversation as it goes on, the election litigation, how the court works, how people perceive judgments coming from the court, especially the Supreme Court, because most people feel if my case is not at the Supreme Court, that means it is not a case that I have won, and people love going to the Supreme Court. The Supreme Court is sort of overwhelmed by these cases that are, pending. Some of them have been shelved, waiting for new cases to come up. How do they cope, and what do you think it does to democracy in Nigeria?
Recourse to the courts is the proper procedure for anybody who's aggrieved at the aftermath of an election. Post-election adjudication has been part of our jurisprudence since before now, even before this current political dispensation. I have been listening very gleefully on the submissions made by my learned friends at both sides of your network centers, and I will say very much emphatically that it is not proper to discourage litigants from going to assert their rights in courts. It is not a very good development for us, for instance, in our era of political dispensation, to shut down clients. At least people go to court because they are aggrieved for one reason or the other. Our jurisprudence is still developing in the area of election petition, and you cannot dissolve a grievance in the mountain or seas of frivolous petitions on the ground that it is frivolous. What is important is to get the electoral process right from the beginning, and to get the courts to understand what electoral adjudication is all about. It's not the regular election petitions adjudication is not the regular civil law principles that apply, or that is sui generis. And for that matter, it is very, very important that some of these principles that apply globally, for instance, the Accra Declaration on the Principles of Electoral Justice, must come into being. I don't think it is proper for lawyers to be found wanting because they come to present the cases of their clients in court. They are immune professionally from doing that. If a matter is frivolous right from the beginning, you find out, if you look into the depth of it, you see some elements of grievance, some elements of wrong that has been perpetrated. And so it is very much contrary to the development of our case law, to the development of our jurisprudence, to begin to put in that hammer to find lawyers in costs, to find them in bringing frivolous things. The principle has always been there that if a matter has been settled, or if a principle has been settled, it is unprofessional for a lawyer to bring it to court. One of the ways we can stop this avalanche of cases going to pre-election matters, post-election matters, going to the tribunals, going to the court, is to ensure that the democratic process is followed in its traditional form. Is to ensure that people do not put the law into their hands and do what they want. At the beginning of this discussion, Kingsley made some mention about the INEC admitting that there are some bit of malfeasance in the last presidential election, and we've not heard anything that anybody's been arrested. Are they above the law? And for instance, we are yet to have a proper electoral offences commission, apart from the electoral offences stated in the Electoral Act and probably in some of these criminal laws that we have. And we don't have a very effective measure to doing it. So the proper abode to checkmate these ocean of cases moving to the courts and getting the courts overburdened is to ensure that the democratic system of election is proper and it's good and it's well established on credible grounds, on transparent grounds. When you do a wishy-washy thing and somebody raises this objection and says he wants to go to court, you cannot shut him out because you think his own case is frivolous. What makes it frivolous? The court must have to define what amounts to frivolity in election petitions, what amounts to a case that will waste their time or waste their energy or waste resources unnecessarily before anybody can accept that you can shut people out from the court. Access to court is a fundamental right. It is a right under the Constitution that you must have access to court. Under Article 7 of the African Charter on Human and People's Rights, people have the right to ventilate their anger, to ventilate their vex in the court of law. And when the same court of law tells you that your vex amounts to nothing, it then becomes very problematic. So I do not ascribe to that. I think the court will have to sit up. The court will have to understand that there are these principles that are universal. It's there in the ECOWAS protocol on democracy and elections. It's there in the African Union principles on democracy, elections, and governance. It's there in a lot of international instruments on the minimum standards of electoral adjudication. They have the Accra Declaration, the UNDP Accra Declaration on the principles of electoral justice, which sets out in very elaborate form what should amount to electoral justice. Not when you begin now to heap technicalities on genuine cases of grievance. And you now say that, well, at the end of the day, there are cases that should not come to court and there are cases that should come before us. I disagree totally on that. Thank you.
Thank you very much. That's your first salvo in this conversation. We apologize for the earlier technical glitches that we had. I still want to stay with you. There are concerns about electoral justice arising from what you said, the ocean of election litigation. Are litigants getting electoral justice? And depending on what your answer is, what could be responsible for this? In the popular thinking, I mean, we're all lawyers, with the exception of my colleague, Juma. And the popular thinking, somebody will tell you, in the house. somebody will tell you, oh, a person who didn't come first or second in an election got declared as the winner of that particular election. Oh, somebody who didn't participate in a primary also, that was named as a candidate. We're saying this in the popular thinking. And of course, that does harm to citizen confidence in an electoral process as well as in the judicial system. Is there electoral justice being dispensed, either on account of the deluge of cases or in the way and manner the cases are handled?
That's a very good question. The concept of electoral justice is founded not on law, specifically, but on common sense. It's a matter of logic to deduce that if the subject matter before the court is who has the mandate of the people, that mandate should form the core, the subject matter of adjudication. If you go outside it and begin to seek other things, for instance, whether the process was properly commenced, either by way of originating someone's or writ of summons or petition, or begin to find out maybe whether the person obtained English language in his O levels, then you are going outside the realm of electoral justice. Thank God that there's been a clear-cut distinction between pre- and post-election adjudication. So I even quarrel with the Electoral Act for making the issue of qualifications of candidates, whether they met the minimum qualifications as contained in the Constitution, as a matter for elections petition, a post-election adjudication. I would say with every bit of confidence, Kingsley, that electoral adjudication has been misunderstood in this country. The concept of electoral adjudication, if you look at it from the point of view of its universal application and its universal significance, is essentially that the ballots, who won the votes, who has the mandate of the people. If you bring any other thing to it, then it is now the tribunal or the courts that are deciding for the people who should represent them. All the flaws arising from maybe a candidate coming from the primary all the way to the level of election are things that should be left as pre-election matters. And even if they are pre-election matters, the expression of the people should prevail. The concept of elections is rooted in the expression of the mandate of the people to a particular person. And if it is thwarted because of technicalities or because one thing or the other comes into play, then it becomes a different thing altogether. Like I stated, the Accra Declaration on the Principles of Electoral Adjudication, which was done under the United Nations Development Program, of which Nigeria participated, clearly outlines what amounts to electoral justice. First of all, that the concentration should be on the ballot. That if it means bringing all the ballot papers from all the 770-something thousand polling units for counting before the panel, even before the Supreme Court, there's nothing wrong with it. It accords with electoral adjudication. That is what it is meant to be. When you attach so much legalese so much technicalities into electoral education, you kill the concept of election, you kill the concept of the mandate, which comes from the people, which is a fundamental right. Article 13 of the African Charter clearly spells it out that it is the right of the person to participate in the electoral process either freely or either directly or indirectly. You also find out in Article 19 of the Universal Declaration of Human Rights. You also find out in Article 19 also of the Covenant of Civil and Political Rights. So we have to get it very correctly that the proper adjudication for election petitions must be focused specifically on the ballot and nothing more. Any other thing is extraneous to it. I hope I've answered your question, Kisley.
Thank you very much. Yes, you have answered the question, and many, of course, will argue that if you are focusing solely on the ballot, there are processes that appertain to the ballot itself, and if those processes aren't right in the perception of a litigant, then you also have to resolve those processes. I'll come back to you in the course of the conversation, but let's return to our studios here. Osaze, one of the issues that Oguche raised, again, it's also been in the public domain. I recall this was a matter that was also equally raised at plenary, excuse me, in the National Assembly sometime in the past. It had to do with technicalities rather than justice, as some persons will say again in layman's language, to say there's too much focus on technicalities. Yes, election petitions are sui generis, they are unique, there are ways you go about them. But if the end is justice, people are also asking the question now, I mean, for those who know, look, if the origin of the principles of equity was to deal with the hardship occasioned by a strict application of the law. In other words, if you were to present your case in a particular form and you didn't present in that particular form, then you lost the case, whether the merit of it was examined or not. Which is why Oguche was earlier talking about originating summons and writ of summons. I know that there are different, as much as we can explain it to our audience, how do we get around this in our electoral jurisprudence in particular, so that at the end of the day, there is electoral justice?
First of all, we should understand the concept of justice in our modern day society is justice according to law. Justice in accordance with law. And you said it. In trying to achieve this justice, there are processes which you must follow. You brought in equity. We should not take this turn this into a law seminar. So we have to be very careful that we're speaking to a much broader audience. So I'm trying to break it down as much as I can. But election rights, in a sense, are according to the law and the processes outlined in the law. You can't stray too far outside of the scope of the law. So a lot of these things now, we say, look, do it in accordance with what the law says. That's why I said, for example, we shouldn't place too much reliance on social media and the evidence, quote unquote, that we see, facts that we see from social media, because they are not tested. So if you say justice, I can, from this recent presidential election, I could have said, okay, I've seen so much on social media. Based on that, I can say the justice seems like X won or Y won, or the declaration was good or the declaration was bad. But we have to be very careful. And I agree with him that, yes, there are certain fundamentals that have to be complied with. And the base thing, and I think even the Supreme Court has said so, basically, what is the expression of the will of the people? That should weigh heavily. They've said so. How often they have followed through with that is a totally different thing. People still don't understand, for example, Amechi against INEC. Amechi's case, why Amechi, who did not partake in the elections, in the eyes of the common man, was returned as governor, against Omehia, who did not participate in the primaries. A lot of the time you are balancing different issues and different concepts. Now, Amechi was named, for example, I'm taking a past example that is very popular, and I'm trying to avoid the present ones, because those are probably subject are going to be subject to litigation. Now, in that case, for example, we said you cannot substitute somebody who won the primaries except with good reason, verifiable. But the PDP went and they substituted, would not give any reason, and brought Omehia. Now, the Supreme Court made its decision, and in its own eyes, in the eyes of the law, not in the eyes of anything, in the eyes of the law, based on their own interpretation of the extant acts and regulations, Rotimi Amechi was the candidate of the PDP, and since the PDP won the election, there's no need sending that case back to the electorate. The electorate has voted, and they voted for PDP. So, being the candidate of the PDP, because independent candidates are not allowed, being the candidate of the PDP, Rotimi Amechi was the candidate, and that's why I said go and swear him as governor. To some people, did that make justice? Some people say yes, others will say no. But so depending on what prism you are looking at the issue from, most of the more popular cases, there is sometimes a misunderstanding of all the facts or issues presented before the court. As Yusuf Usman in Kaduna said a while back, a lot of the time, how do you commence a process? The Federal High Court rule says you do it by a protocol or written summons. You don't need to call witnesses. All you have to do is swear to an affidavit supporting your claim, and then the other people that are disputing swear to another affidavit. But the Supreme Court said no. If the facts are so disputed, for example, if you allege forgery, fraud is a serious criminal offense. You cannot do it by affidavit evidence. You must call people so they can be cross-examined. You must tender documents. You must call experts to look at these documents. But these things also take time. The essence of why the chief judge of the Federal High Court made it that you should come by way of originating someone just by to make it quick. Because it's 180 days. You must file a case, hear a case, and one of the things we must commend the judges for is that they have tried not to allow any case lapse. They have tried within what is human, to ensure that a decision is given on every case. Because if you file a case and people do that in as 181 days, the case lapses. You cannot even appeal. You cannot do anything. It's just that will not meet the ends of justice. So these are the things. And by the way, equity doesn't come because the rights are statutory rights. They are rights given by the Electoral Act or by the Constitution. You cannot now bring any other thing. It's not the common law rights. You cannot bring other issues. So you must stick to the laws and the framework and the guide that have been provided in the law.
Okay, thank you so much for your comment there. The conversation will continue after this break as we discuss election litigation. Welcome back. This is still Good Morning Nigeria. We're still discussing election litigation. Let's join Yunus Usman San in Kaduna. Usazi talked about the exclusiveness of the High Court to handle election petitions and election cases. And while swearing in the judges for the Federal High Court, the Chief Justice of Nigeria was emphatic in saying that they should not bring disrepute to the judiciary, because before the primaries itself, we were seeing court judgments back and forth from different courts on the same issue. Do you think this warning would be adhered to by judges?
Thank you very much. Before then, may I correct one impression made by my learned friend from Port Harcourt. He said, and I agree with him, that election matters must be decided in consonance with the votes cast. The qualification to that is that now if you are just counting the votes, what in cases where one person sits down and thumbprint many ballot papers. If you give that person, the person who has those number of ballot papers, if you say he's the one who won, have you done justice to the society? Have you done justice to the opponent? That is why there is no way you can really divorce election, some essential technicalities from election matters, particularly election petitions, because those technicalities are used as a sieve to get to the real truth, to get to the real number of, that is what we call valid votes. If we go by Oguche's analysis, it means every vote will count. No. It is not so at all. And that is why in most cases where you are not even satisfied, make sure that the votes are recounted so that you see the valid ones from the invalid ones. And then in that case, you are going into technicality. There are some instances, even in life, you can't divorce essential technicalities. For example, I can't go to church without, as a man, without removing my cap. Am I not free to go and worship? But that is a rule. I can't go to the mosque without removing my shoes. Am I not entitled to go to the mosque and pray? But I must do these things. So there are things we call intrinsic technicalities in nature. You can't avoid those ones. Even God saw Adam and Eve commit the offense, but he didn't try them until he investigated and said, did you? That is technicality. Now to your question. The issue of contradictory judgments. Contradictory judgments will not really help the confidence of the people. No. And we should try as much as possible to curtail contradictory judgments. Well, fortunately, the retired Chief Justice of Nigeria, Justice Tanko, disciplined some judges, and I think some in Dusi who entertained a matter from Port Harcourt and so on and so on. I think that discipline has to be more amplified now, particularly in election matters. In election matters, they have to be amplified. If necessary, a case decided by the Federal High Court should be circulated to the other judges so that they know what the other has decided. Because once there are too many contradictory judgments, people will lose confidence in the judicial system. And that would not be good for us. Because the other arms of the government, even if they are not there, we can have a sane society as long as there is confidence in the judiciary. But so far, we thank God, it's not, people orchestrate some of these things, like I said, without reading the judgment itself. We pray that the judiciary will continue to uphold the rule of law as it does today.
Right, thank you very much, Senior Advocate Yunus Ustaz, for the points you've raised. Earlier, you did talk about some of the reports that we get about court cases, either in the course of the trial or at the time of decision. So some of the correspondents are not quite familiar with what's going on, and I'm sure Sajay is also used to this. If some media houses in the past had ensured as a point of training that only the most competent hands went to report the courts. I'll give you an example. There's some examples from the Nigerian Television Authority. Femi Okewo, for instance, Vera Chimuba. They are lawyers. Yes, they cover proceedings of the court, so they have a clear grasp of the issues. And of course, well before him, you also had others who were very familiar with court processes. The Guardian newspapers took judicial reporting very seriously. Richard Akinola was one of the early court reporters. Kunle Sonyalu, who also became a lawyer, and is a lawyer, has been a lawyer for well over 25 years, for judicial editor. Bolahon Badamosi also, of course, read law and was covering the judicial bit, along, of course, with Editor Ojo. So those are the kind of things. I agree with you. Sometimes in making comments, our first part of interaction is with the reports that you get. I mean, look at the Supreme Court decision on Friday. I've been struggling, for instance, to grapple with the nitty-gritty of, as we said, again, to reduce it, the ratio. It's difficult that I'm looking for the ratio in the decisions, and I can't get it. I heard, for instance, that it was a full panel, 7 justices of the Supreme Court. Now, was it a unanimous decision? Was it split? Nobody has mentioned that in the first instance. You mention one aspect to say, oh, the Supreme Court said they heard as follows. You don't give us the reason why the Supreme Court heard as follows. I'll give you one before we proceed again on the election litigation. You say the Supreme Court has struck down the Naira redesign policy. Does that mean that the new Naira notes have been invalidated? And yet, in the same report, you are telling us that the validity of the legal tender status of the old Naira notes has not been extended to December 31st. Does it mean that we are to keep our new Naira notes and then be using the old ones on the December 31st? Is a new currency or new notes likely to come out? So these are some of the issues we get, and I'm sure that will form opportunity for training workshops for those who cover the judicial bid. Thank you very much for raising that, Eunice Stars. Back again to Festus Oguche in our Port Harcourt studios. Mr. Oguche, tell us something, because yes, you say it is the right, and I agree with you, of any aggrieved person to seek redress rather than resort to self-help. But it appears also to have just become part of our electoral process, beginning with the primaries that sometimes are just nothing but acts of shenanigans, and somebody will let you go to court. In other words, persons appear more interested in being respondents rather than petitioners in election matters, or the prelude to election matters, rather than doing the right thing in the first instance and then reducing the volume of matters that courts have to deal with. How do we get around all of this and attenuate, the frequent penchant of saying go to court?
Fantastic question. Before I go into your answering your question, I must express my satisfaction with the views expressed by Saze Yamo. I think he has coming from the background of INEC. I think he has quite a volume of experience, and based on his interaction with some of these principles directly. But I am saying that if we now sit down to discuss the concept of justice, we can be here till the next 5 years. I will not conclude it. The varying views of the jurisprudence on legal theory, from Hans Kelsen to Honorable Justice Holmes, the realist school, the legal positivism. But if you boil it down to elections, you now know that you are talking about nothing but the popular will, the expression of the popular will. That is the ballot. And that pertains to sovereignty. So if you're saying that justice in election petitions is justice as to law, sovereignty is also as to law. Chapter 2 of the Fundamental Objectives and Directive Principles of State Policy state very, very clearly that sovereignty belongs to the people from whom government exercises its power and authority. So it is not simply that maybe we are going to rely on facts if you are dealing with the ballot, or you are going to rely on extraneous matters that are outside the law if you are dealing with the ballot, because the ballot itself is law. Kinsey was here one of those programs where you formulated a principle that I find unassailable, that the ballot also has a human personality. Unfortunately, our electoral law does not allow me, for instance, to go and challenge an election petition in the courts, so to speak. But then we still have to boil it down to the fact that persons that are aggrieved by the election process have the right to express themselves by ventilating their grievances in the courts. And when they do that and the courts fail to satisfy their yearnings, of course, you know how the effect it will have on the law, on jurisprudence, on societal development, on peace, on tranquility. And that is why we find ourselves in this sorry pass, that all the years of adjudication have not been very much satisfactory, because somebody had not explained to me satisfactorily why somebody who came the fourth place in an election is the winner of that election, or why technicalities should be applied in terms of the quorum of judges or justices, and the apex court to rather throw away the petition instead of taking it back to that particular panel to form a quorum and take a decision on it, as happened in the former Osun state elections, not this recent one, the past one. A whole lot of issues are there. And the public confidence in the judicial system is lowering every day to very drastic levels. We have to state these things carefully. And that also answers your question to a large extent, because a lot of theories have been propounded as to what happens. Is this the weakening of the judicial system? Is it the undue interference of the system by political elites Is it the fact that the Constitution has made it possible that the executives are the ones virtually running the judicial system in terms of finance, in terms of appointments, in terms of even discipline? And the NJC have been found to be, to be susceptible or vulnerable to arm twisting tactics sometimes. These things, we have to bring them to the open forum, because we are trying to create an ambience for the good of this country and for the development of our jurisprudence, particularly in the election matters. The recent elections of last week has been bugged with a lot of objections all over the place. Should that be the case? If elections are free, fair, credible, and transparent, I bet you, Kingsley, that there will be less of election litigation in the courts than what we have now. Thank you.
Let's come back to the studio. As I say, experts think that election litigation and petitions is the culprit in interfering with the calendar of democracy in Nigeria. Now we have 28 states going for the governorship election. We have off-cycle election. Some say it's not giving enough time for INEC to prepare for the next election in 4 years, because they are busy running off-cycle elections and incurring lots of cost in the process. What's your take?
I find that difficult to comprehend, because one of the panelists did say our system is modeled on the American presidential system. And the American presidential system, for example, you have midterm elections. All elections don't take place at the same time. Yeah. So I think it provides for more efficiency, because if you did only that, what will they do in between? And it's a quirk of the process that will now have some off-cycle governorship elections. Don't forget that arose out of the interpretation of the law in Peter Obi's first case against Ngige, where it says it's 4 years from the swearing in of the candidates. It started from Peter Obi's case against Ngige, but reinforced when in 2007, INEC now added Anambra as one of the places where it will conduct governorship elections. In the meantime, Peter Obi had not spent 4 years as governor. So that's that's how it came about. And don't forget that the off-cycle governorship elections like that afford the Commission the opportunity to test run some processes. So, for example, the Beavers card was first test run. People complained about the card reader in 2015. They said you should have used one of the off-cycle elections to test run it before introducing it in the general election.
Which INEC did.
Which INEC now did with the Beavers, which worked so well in some off-cycle elections, but things happen in the general elections. So, but it affords the Commission the opportunity of test running the processes, test running the law, test running everything else. So I think it will provide for more efficiency, because what will the Commission be doing? Just planning, and you must implement some of those plans at some stage. So you can take the by-elections and the off-cycle elections as opportunity to test run these things. Find out how well they did, where there are mistakes, how can they be corrected, where there are challenges, how can they be overcome. So I don't say anything wrong. In fact, many people on the contrary who study these things say it probably would be better to take another leaf from the US system and do midterm elections. Don't do all the elections in one fell swoop. General elections are more peculiar to parliamentary systems, actually, and that's why this debate is it general election or is it general elections? Because in a general election, in presidential system, you do presidential elections, you do governorship elections, executive positions, you do for legislative positions, you do state, you do federal. So that's why it's considered. But I think, to answer your question, that it's a good thing, and maybe we should even consider whether we should do more off-cycle elections or find a way to break. The only challenge with that was that I think that issue was very much alive in 2007, where people saw it as another behind-the-scene tenure elongation kind of a thing, where they said, look, maybe do one term of 6 years or 7 years, or do half the legislature should do election this year, in next cycle, and that have to do it. But it's got controversial because of the modalities for putting it in motion.
All right, Osaze-Ozi, thank you very much there for your explanation. We're on the home stretch of this conversation, and I would like to return to the learned Silk, Yunus Ustaz Usman. Same question that I posed to Festus Oguche earlier, I would also like to ask you. The penchant of persons who, as you earlier indicated, do not abide by their own party's rules, do not abide by their own party constitution in conducting primaries, and therefore you give rise to litigation. People will say, go to court, that's for pre-election matters. And then when it comes to election proper, where all kinds of shenanigans get to take place in some instances, and you say, look, you go to court. And some persons have argued that it's usually a mountain to climb for a petitioner, particularly if you are having to prove electoral fraud. We know how difficult it is, we know how painstaking and how costly it is. All you have to do in a pressure cooker environment. I mean, Adams Oshomole will tell you how difficult it was for him in 2007, 2008 to get the governorship of Edo after April 2007 elections. I recall that case vividly because one of the publications of the Nigerian Observer was taken as Exhibit 105, which was a fake result that was published after the polls had taken place. So it looks like it works hardship on the petitioner when he's told go to court, because they know that he has a mountain to climb and probably obviously run out of oxygen just going upstairs.
Hey, sir. In fact, even in legal practice, you always pray to represent the person who might have won, because that is easier. In practice, it's easier. Because the burden is on the petition, that is the person complaining going to court. The law presumes that the person who won has ordinarily won. And so the politicians in Nigeria in particular rely on this and tell their parties, look, whatever happens, you make sure you win. But that is not good for us. It's not good for justice. It's not good for us. And I think it has come to a stage now that the burden of proof should be upon a preponderance of evidence. If I have established even fair allegation against you, don't say it must be proved beyond reasonable doubt again. Because what is happening really is that our politicians have developed their own jurisprudence now. Say, all we want there is that you should win. They then will go and defend. Because they know that it is not easy to defend. And, for example, where you are thinking of overvoting as a ground and so on, that is extremely impossible to prove now, because you have to call the witnesses from each polling booth to those who counted, how they were thumb-printed and so on. For example, in a presidential election petition, how is that possible? And then that takes me back, I'm sorry for taking you back, to my learned brother, Oguche, on this issue that you don't even use qualification and so on. You need qualification for everything. You even need qualification to marry. Yes, because if you are not mature, you can't marry. If you are not a man, you can't marry. So you need qualification. The issue of qualification is